dengan dilandasi keyakinan. UT mampu beradaptasi dengan setiap perubahan dan sumber daya manusia yang excellent, serta memiliki jiwa dan karakter Pancasila yang kuat. Universitas Terbuka siap menyongsong era baru pendidikan tinggi jarak jauh di tanah air yang modern menuju Indonesia maju.
Dahulu, ketika UT didirikan pada tahun 1984, tidak sedikit orang yang memandang sebelah mata Universitas Terbuka. Hari ini kita percaya bahwa UT telah menjadi perguruan tinggi negeri yang besar, berdiri sejajar dengan perguruan tinggi lain yang lebih dahulu didirikan, bahkan terdepan dalam pendidikan terbuka dan jarak jauh. UT menjadi instrumen penting pemerintah dalam pemerataan pendidikan tinggi berkualitas dunia ke seluruh pelosok tanah air, bahkan mancanegara. Sulit rasanya meningkatkan angka partisipasi kasar pendidikan tinggi tanpa kehadiran UT.
Seiring dengan berubahnya status menjadi perguruan tinggi badan hukum atau PTNBH, yang membuatnya sejajar dengan perguruan tinggi terkemuka di Indonesia yang lebih dahulu didirikan, UT semakin lincah dalam merespon beragam tuntutan internal dan eksternal dengan melakukan terobosan baru yang inovatif dan adaptif. Dengan semangat, tatanan dan budaya kerja baru mewujudkan Indonesia maju. Perkembangan teknologi yang ramah pengguna, terjangkau, tersebar, serta semakin meningkatnya literasi digital masyarakat. UT semakin mendapat tempat di hati berbagai kalangan. Hal itu tampak pada terus meningkatnya jumlah mahasiswa dan dalam 5 tahun terakhir, jumlah mahasiswa usia muda terus meningkat. Menyadari karakteristik dan kompleksitas pendidikan jarak jauh dan masyarakat yang berubah dengan cepat, UT melakukan investasi yang signifikan untuk penyediaan infrastruktur modern dan SDM yang berkualitas. Gedung Profesor Setiadi menjadi landmark keseriusan UT dalam menjadikan teknologi modern sebagai tulang punggung layanan kepada mahasiswa dan stakeholders lainnya. Gedung yang dilengkapi peralatan terkini, siap memberikan layanan online terbaik.
Pada tahun ini, UT meluncurkan aplikasi MyUT yang memudahkan mahasiswa mengakses semua layanan pendidikan dengan menerapkan teknologi Sistem Single Sign-On atau SSO.
Dalam mewujudkan akuntabilitas keuangan, UT mengimplementasikan transformasi digital tata kelola keuangan atau yang disebut dengan SIP3, Sistem Informasi Perencanaan, Pelaksanaan, dan Pertanggungjawaban Keuangan.
Dengan demikian, setiap kegiatan dapat memaksimalkan value, meningkatkan kinerja dan kontribusi, serta menjaga keberlanjutan UT dengan prinsip transparansi, accountability, independency, responsibility, dan fairness. UT mengembangkan aplikasi sendiri yang diberi nama Smart Procurement Management Information System yang disingkat PROMIS.
Aplikasi ini sudah mendapatkan penghargaan dan apresiasi dari sejumlah lembaga pemerintah, termasuk perguruan tinggi negeri yang sudah menggunakannya.
Sebagai jantung sebuah perguruan tinggi, Fakultas memiliki peran penting dalam memberikan layanan akademik dan terus berpacu meningkatkan kualitas akademik dan inovasi pembelajaran. Akreditasi baik nasional maupun internasional, termasuk upaya mendapatkan international recognition, terus dibangun. Di antaranya penyiapan bilingual course materials untuk menampung international students.
Kami menyadari bahwa keberhasilan UT adalah berkat kepercayaan pemerintah dan masyarakat. Mari membangun manusia dan Indonesia yang lebih baik bersama Universitas Terbuka.
'Akan
Ladies and gentlemen, we are ready to start. I would like to inform you that this event will be conducted in English. Thank you. General Lecture on Comparative Law organized by Faculty of Law, Sosial, and Political Sciences, Open University, Wednesday, 6 December 2023. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, distinguished ladies and gentlemen. Honorable Vice Dean for Faculty of Law, Social, and Political Sciences, Mr. Anto SIP M.Si, Honorable the Chairman of Law Study Program, which in this case is represented by Mrs. Madiha Zakia Hairunisa, SH LL.M, Honorable Invited Guest, Mr. Sascha, LL.B, LL.M, Ph.D, Assistant Professor of Comparative Constitutional Law, Maastricht University, Mrs. Dr. Rosari Stawati, SH LL.M, Associate Professor, Faculty of Law, Erlangga University, Mr. Dr. Sri Wahyu Krida Sakti, SH M.Si, Associate Professor, Faculty of Law, Social and Political Sciences, Open University, honorable all participants of this event. Welcome to the General Lecture on Comparative Law. First of all, let us praise to the Almighty God because of His blessing, we are able to attend this event. Ladies and gentlemen, my name is Helen Adana, will be the Master of Ceremony. I feel very honored to be along with you here at this virtual room, and let me read out our agenda this afternoon. The first is opening. The second, singing the national anthem of Indonesia Raya. The third, speech. The fourth, material delivery. And the fifth, closing. The first agenda is opening. Let's open this event by reading Tasmiyah together. Bismillahirrahmanirrahim. Hopefully, with reading earlier, this event can run smoothly as it should. As a form of our gratitude for being part of the unitary of Republic of Indonesia, starting the event this afternoon, the second agenda is singing the national anthem of Indonesia Raya. Ladies and gentlemen, please stand up. Please sit down. Thank you. Step on to following agenda is speech. The first speech will be delivered by the Dean for Faculty of Law, Social, and Political Sciences, Open University, Mr. Muhammad Husni Arifin, SAG, M.Si, Ph.D. Please, time is yours.
Assalamualaikum warahmatullahi wabarakatuh. Very good afternoon, everyone. Dear distinguished speakers, Mr. Sascha, Ph.D., Dr. Radian Salman, SH, LL.M, and Dr. Rosa Ristawati, distinguished moderator, Dr. Sri Wahyu Kridasakti, SH, M.Si, Honorable Chair of Law Study Program, Universitas Terbuka, all lecturers, tutors, and students of Law Study Program, and all distinguished participants of this general lecture. First of all, let's give praise and thanks to Allah who has given us all grace and health so that we can attend this webinar and carry out our daily activities well. I would like to express my thanks to the distinguished speakers who have a willingness to be speaker in this general lecture. And especially for Mr. Sascha, I would like to welcome you to Indonesia, and I hope you can enjoy your stay at Indonesia. I express my appreciation to the Law Study Program which took the initiative to conduct this general lecture on comparative law. It is very important issue that we should pay more attention to comparative law pedagogic in today's world, where law graduates must be prepared for working in global context. Whereas in academic comparative research, the goal is to reach a deep cultural understanding of foreign law, as the goal in legal education is to learn to think like a lawyer. It is argued that by means of teaching foreign law, it is possible to transfer the focus of legal learning away from the 10 rules and instead concentrates on general principle. Ladies and gentlemen, this general lecture is part of internationalization programs for the undergraduates program of Law Study Program, and as part of preparation to offer the master program in law in the next year. Now the Bachelor of Law Study Program had achieved a accreditation by National Accreditation Board for Higher Education. I do hope this general lecture will strengthen student competencies in comparative law in the era of globalization, and hopefully the quality of legal reform in Indonesia is increasing, supported by better comparative law studies in the future. Finally, I would like to express my thanks to the speakers, Chair of Law Study Programs, and all the committee members who have helped organize this general lecture. Enjoy participating in this general lecture and get benefit from it. Wassalamualaikum warahmatullahi wabarakatuh.
Thanks to Mr. Muhammad Husni Arifin, SAG, M.Si, Ph.D. for the enlightening speech. Ladies and gentlemen, now we are about to enter the first event. The first event for today is the general lecture on comparative law. In order to pioneer the strengthening of law study program services, a Master of Law Study concentration area, we plan to utilize legal experts to implement a collaborative grant strategy in the field of legal education at national and international levels. Let me introduce our bridgeman, Mr. Dr. Sri Wahyu Kridasakti, SH, M.Si. He is one of our grad lecturers who will lead this session with the speakers. Please give a round of applause to welcome Mr. Dr. Sri Wahyu Kridasakti, SH, M.Si.
dear audiences, that there will be two topic titles to be addressed in this session. First, so-called perbandingan hukum, tujuan, metode, dan perkembangan di Indonesia. It's going to be delivered by Dr. Rosa. Okay, should I repeat it? No, I don't think so. I just continue there. Oh, repeat. All right. Good afternoon, everyone. Assalamualaikum warahmatullahi wabarakatuh. Yeah. With respect to all of you, these authorities and everyone who attends and participate in these sessions, welcome to today's seminar about the comparative law. This general lecture will be addressed bilingual in two languages, English and Bahasa Indonesia. And there will be two subtopics titles to be addressed. These are first, perbandingan hukum, tujuan, metode, dan perkembangan di Indonesia. It's going to be delivered by Dr. Rosa. And second, the title is going to be constitution making, concepts, context, and complication by Dr. Sascha. It's very interesting, this one. All right. Dear folks, my name is Sri Wahyu Krida Sakti. You may call me Wahyu, and I'll be your moderator, or not moderator right now, as a bridgeman for today's general lecturing, because today's format is general lectures, so there will be no moderator, just only a middleman, a bridgeman who facilitates the lectures today. Dear audience, to give you an overall of what we'll be having today, we will be covering, as I said, the issues of comparative law as our program session in this afternoon. Due to this format as a public lecture or as a general lecture, there will be actually no question and answer sessions. But later we can see it, we will see that after the comparative law presentation session from our two extraordinary resources persons, whether there is any still time left or not. Okay, and then we will use it for question and answer. But I doubt it if we can still have a time, but we can see it later. Without further ado, let's get started. And as we know that we have a great agenda for you today, and we will have a following with subtopics first in here, perbandingan hukum, tujuan, metode, dan perkembangan di Indonesia by Dr. Rosa Ristawati, SH, LL.M. And before we begin, let me address a bit of protocol of these sessions. This session basically consists of a speaker introduction, speaker presentation, and conclusion. And each guest speaker will be given around 20 until 40 minutes maximum for his presentation upon my call. Firstly, I'd like to introduce our magnificent guest lecturers here. First, Dr. Rosa, as he is a renowned expert on the issue of comparative law, and she has also has been publishing plenty of books, articles in the subject, and she has assisted professors comparative law. And he is from the Faculty of Law, Airlangga University, and also as a consultant in many higher education institutions. Please join with me in welcoming Dr. Rosa. Yeah. Yes, Dr. Rosa, and I've been introduced you, and then times and place is yours.
Thank you, Pak Dr. Sri Wahyu, for the opportunity. Good afternoon, everyone. Assalamualaikum warahmatullahi wabarakatuh. So, first of all, I would like to send my gratitude to the University of Open University, Universitas Terbuka, specifically for the Dean of the faculty and then the Vice Dean as well, Pak Dr. Sri Wahyu. Thank you so much. This is an honor for me to be here, and also all the colleagues from the University, Open University, Universitas Terbuka. Apologize because I have to get used with the university, first university of, yeah, but this is Open University, okay. My first impression, I have to say this before I start my lecture. My first impression to come here is just wow, and amazing, amazing campus, amazing colleagues, and I think maybe also I have to send my greeting to all of the students in the Zoom. Good afternoon, everyone, students in all over Indonesia. Thank you so much. This is once again my honor to be here. So my topic this afternoon is about comparative law, purpose, aim, method, and the development in Indonesia. I will deliver this lecture. Actually, I have 20 minutes. But I will do my best. Comparative law, or in Indonesia we call it as perbandingan hukum. I think this is the very good stepping stone for Universitas Terbuka, which will offer the course in Magister Hukum, Magister Hukum for the next years. Because right now here in Indonesia, perbandingan hukum is already more and more important and more familiar in the legal education in Indonesia. I think almost all the Faculty of Law in Indonesia also offer the course comparative law, perbandingan hukum, and more and more students also interested in joining the perbandingan hukum in Indonesia. So first, what is actually the perbandingan hukum, and what is it for? What is it for? If I may, Pak Dr. Wahyu said that I can deliver my lecture in bilingual, so I will maybe I will firstly have a question that why we need a comparative law, why we have to compare, or what is for the comparative of law. So if I may, I quoted from three of the scholars, the academia, who actually already well known for the comparative law atau perbandingan hukum. First, Zweger and Court. Oh, okay. Here, this is what I actually have to familiar with, because we usually have a very huge class with the student, and now I have colleague in front of me. This is a challenge because it's like me myself, I have to defend my dissertation here. Okay, so Zweger and Coates said that perbandingan hukum, or the comparative law, is an aid to the legislative process, an instrument of interpretation of the law, and the vehicle for teaching law at the university level. It is also for the promoting legal unification. He said so. So I would like to relate this theory from the Zweger and Coates with what we have in Indonesia. If we refer to the first aim of the comparative law is an aid to the legislative process. What we see now in Indonesia is actually, it's true. Comparative law is become alat bantu untuk sebuah undang-undang, dalam proses undang-undang. For example, like we have Mahkamah Konstitusi. Because I'm from the constitutional law, I will have example more in the constitutional law area. we have Undang-Undang Mahkamah Konstitusi, which we know exactly that before Undang-Undang, before the bill of the law become the law, sebelum rancangan undang-undang menjadi undang-undang, they study comparative of what is actually the constitutional court, what are the competencies. So the study coming from other countries which they already have the constitutional court, and then they make it into the norm and become undang-undang. So this trend is actually, we see it until now. For example, Undang-Undang IKN, if you see the draft of the bill, then naskah akademik, they have the comparative part. So what we have see in the legislative process, actually, they become more and more important to include the comparative study. At this context, comparative law. They do the comparative law, even though maybe it's not really that comprehensive, the study of some issue. So at this context, I will say that the theory from the Sweetgard, an aid to legislative process. Yes, we do need the comparative law. And then an instrument of interpretation of the law, interpretasi sebagai alat untuk menginterpretasi sebuah undang-undang. Well, this is also what we see in the several putusan MK di Mahkamah Konstitusi court decision. I think if you read some of the decision, you will find that the judges refer to the other countries' practices. So at this context, maybe we can say that they do the comparative law. Mereka melakukan perbandingan hukum pada saat mereka memberikan legal reasoningnya, pertimbangan hukum. But then maybe in some point we say that, okay, that there is not a comparative law because it's not really that comprehensive, the study that they have in the court consideration. And then the other scholars, as in Urucu, which he also famous with the comparative law, said that comparative law is a very important for the law reform and policy development. Untuk pembangunan, untuk reformasi hukum dan pembangunan kebijakan. Well, this is what we see also in Indonesia actually. We see that comparative law is for building a system, develop the system. So maybe we are lawyer, we see that now legal system in Indonesia is more developed. Whether it is developed in a better way or in the other way, there is another debatable issue. Another scholar maybe the same thing with the previous scholar, that the comparative law has the function, has the aims to formalizing the function, building the system. What I said about the Mahkamah Constitution is one of the example that comparative law has benefit to building a system, building a court procedural system. So we have a complex system when we see that we have a constitutional court. We see that the court has the procedure. The court procedures, they build up the system from the comparative law. So at least we see comparative law at this context is very important for us Other than that, of course, that we are in academia, we are in the academic field, we are in the university, we really need to do or to study the comparative law. Why? Of course, that because we want to expand our legal science, our legal understanding, to construct a new idea, to propose a new idea on how the legal system in Indonesia can be a better system. So there is all the benefit, there is all the purpose of the why we have to do the comparative law. Okay, so in my slide, I have how do you say? I have an argument that actually during, well, a decade maybe, I have a class and I teach comparative law starting from 2009, at least to until now. I witnessing that doing the comparative law is not anymore very rigid as what we had before. So I see the development of the method and the approach in the comparative law. What is the development? I see that the comparative law becomes more and more developed with the multidisciplinary approach. So we cannot stand alone with the perspective of comparative, the real the fact that we need other method to make complex our comparative analysis. Yes, we do need an approach on the socio-legal, for example. We need the other, on the other side, we need economical analysis, for example. So there is more and more development in the method and how we approach an issue of comparative law. And then what I say maybe in the later of my slide, I will show you how the comparative law will be like different in the model, in the research, yeah. So I have method functional method. What is it about functional method? So this method is actually developed in the very early, well, not in the very early, I would say this is developed in a modern period when we recognize that the comparative law in the modern period, then maybe most of the study focus on the functional method. What is it, functional method? The functional method of the comparative law means that the study is focused on the common legal problems. So when we see the common legal problems, then we need to find the solution of the problems, of the common legal problems. Then the solution is the output of what we do with the comparative law. So it means that comparative law has a function to find the solution of the common legal problems. So this may be the method that we still apply until now with the comparative law. So other than that, maybe other scholars like Esin Urucu, yeah, Esin Urucu. How can I pronounce it? Esin Urucu is from Turkish, right? Urucu. Okay. So he observed 6 of the method to do the comparative. So first, of course, that functional method. So what we will do with the study of comparative law, we want to find the solution from the comparative study. So other than that structural method, we do it step by step. First, we do or we find the similarity, we find the differences, and then we want to make it structures from the similarity and differences, how the new construction we want to propose by the comparative study. And many and other method like analytical method, of course. We do the evaluation, we do the analysis of why an issue being compared is different, analyzing, evaluating. And what actually right now being more and more interesting is comparative law, which we have an approach as a law in the context. So this may be the type of the comparative law which we make it into different perspective of multidisciplinary. So we don't anymore only focus on the norm, tidak difokuskan pada hanya norm in the peraturan perundang-undangan, but then implementation, implication of how the norm being implemented in the society. So there is maybe, we see that comparative law right now maybe you see that always connected with the socio-legal study. So that's maybe the development of the comparative law in Indonesia as well. Same thing. And then the common core and other approach that we maybe know from other scholars. What does it mean? Well, at this moment, I would say that maybe comparative law giving us flexibility to decide what method, flexibility to decide whether we stick only on normative things or we do multidisciplinary or even we do interdisciplinary. So I will maybe in my other slide I will also explain more about what is it about the multidisciplinary, interdisciplinary. So this is So other than that, other than method and approach, I also observe that comparative law is always connected with how we choose the countries as the object of the comparative law. So this is maybe the key of doing the comparative law. This is the key of doing comparative law. So in my experience as well, I did supervising the students with comparative constitutional law, which actually in my faculty of law, Universitas Erlangga, we have a specific mata kuliah subject of comparative constitutional law in S1 and comparative constitution in S2. So that's different because in the comparative constitution we do it thematically, and then in the comparative constitution we do the comparative of the constitution. So all the constitution as a document. And then we have a big or general big class actually usually for the comparative law, perbandingan hukum, for the master student. Other than that, we have also the comparative criminal law, we have comparative administrative law, we have a comparative private law as well. So we already developed the subject into not only the general subject of comparative law, but also the specific subject of legal area. So this is the key, the very key of doing comparative law. In any of comparative study you will do, if either comparative constitutional law or comparative private law maybe, the choice of the countries, how we choose the countries. Well, if me, I usually refer to Professor Ranhers. Professor Ranhers, from one of his articles, he mentioned at least to decide which country you want to compare according to the 5 principles. Either you choose the most similar country case, right? Different cases, outlier cases, yeah. So this may be from the Professor Ranhers. Once again, I see that if you do the comparative law, you choose the country, there is a flexibility as well. You don't need to have like country with the very similar country. You have to find the common value, the common mechanism in a country. Even maybe you can choose other country which have a different mechanism. But specifically, again, you have to decide whether it has the comparability aspek perbandingan. So you need to stick with the aspek perbandingan first. For example, like if you want to compare judicial review mechanism, so you compare also about the judicial review mechanism. Do not compare other, do not analyze other country with other aspek perbandingan. For example, judicial review mechanism, tiba-tiba yang dibahas, yang dianalisa tentang kompetensi misalkan. Jadi analisanya ke bawahnya jadi apa namanya? Tidak bukan perbandingan, deskripsi mungkin, hanya mendeskripsikan. It's about descriptive. So you have to stick with the aspek perbandingannya, tertium komparativisnya. At this moment, maybe the old theory of apple to apple, if we speak about aspek perbandingan, then maybe it can still apply. But then when we are in the area of pemilihan negara, then apple to apple cannot be applied. Because you see here that more and more pilihan, more and more choice, prinsip untuk memilih itu semakin bervariasi. Mungkin nanti juga ada pemilihan negara, pemilihan objek perbandingan yang bukan antar negara. So maybe Dr. Sascha will also speak about the European Union, yeah. Yeah, maybe in Indonesia. Well, I also experienced with some of the students which right now start to compare not only country to country, but also country to the regional organization. For example, like one of my students writing a thesis about the data protection rights, data protection, right of privacy, and then he compare Indonesia, other ASEAN countries with EU. Well, that is about flexibility again. So we don't need to like compare two of the or more of the countries, but yeah, you have to find the common issue at this point, at this context, to find whether the system is more established than what we have. So here, again, is a flexibility to compare. Maybe I will come back to, Okay, so here in my slide, I just want to show that actually perbandingan hukum has already familiar long ago, before the period of what we call it now as a maybe digitalization era. Yeah? If you study political theory, ilmu negara, maybe your lecture has already introduced you with philosopher Aristotle, mulai dari Socrates, Plato, and Aristotle. Well, at this context, perbandingan hukum, we see that actually the classical philosophers like Aristotle, for example, he compared at least 158 constitution at the time. Yeah. What is for? Well, we come back to the first slide. What is for? Well, Aristotle compare 158 constitution to make a classification of a good government and a bad government. So he used the comparative study of the constitution to make a classification of bad government and good government. And then, okay, Pak. And then, I just want to show you that, okay, other than Aristotle, there is a Montesquieu, doing the comparative for analyzing the variant of how the Roman law was accepted at the time. And then, the European legal system was established by the comparative law as well. Yeah, I quote from Jan Smith, who is the dean of the Faculty of Maastricht University, in his book Elgar Encyclopedia of Comparative Law. He see that study on comparative law becomes more and more important. He said explosion on the comparative law. Okay, so that's maybe our our introduction to why we do the comparative law, as well as why we need to have the subject on the comparative law. But other than that, I will skip my, there is a challenge to do the comparative law. But do not worry, because we will do it together, study in comparative law, so maybe we can face the challenge together as well. So what is the challenge? Of course that the perception of how we have to be very careful for protecting our local value, because the law has to be built by the local value as well. So don't forget to preserve the local value. And other than that, maybe I'm also quote from William Twining. He said that if we do comparative law, we always become the target of critique, not only externally but internally as well. Why you do the comparative with the that country? Why you use? Why you propose to have that country mechanism and many things of the critic? We have to be very careful against to do the comparative law. And then the most important thing is that if we do the more and more comparative law, one of the scholars said that it means that your state is disorientation, state disorientation, because we seems like we don't know what our legal orientation is. Maybe that's one of the challenges that we face. But of course, that if we do the comparative law carefully and we do correctly, then maybe we can answer all the challenges. Yeah, other than that, in Indonesia, we really have a limited access to the sources. Well, the fact that now digitalization, I said that the prospect that many websites now provided more and more material that very useful for our comparative, yes, it's true, but some of the document we cannot access. And of course, maybe some of the scholar also, the practitioner also, we have a limited, how do you say, kemampuan berbahasa asing. Maybe we can speak English, but other language we cannot understand it. So that's maybe the common challenge that also in Indonesia we still face it. But then the prospect is that more and more faculty of law, they offer the comparative law courses. And more legal practices in Indonesia, right now, we refer to the comparative law. When you are a lawyer, maybe you have your permohonan ke MK, you write a permohonan judicial review undang-undang, you make a justification for your argument, you can use the comparative law. So that's the more and more prospect on the comparative law in Indonesia. Yeah, I think the trend of globalization, regionalization, yeah, internationalization as well. I think that's also the prospect of doing the comparative law. So I would only say that why we are afraid to compare, membandingkan. Why? Because maybe we can have an improvement for our legal system. Thank you so much.
Thank you, Dr. Rosa.
It's great. Thank you, Dr. Rosa, for your excellent explanation and for sharing for your knowledge and experience with us. And I'm sure that our audience has gained a valuable insight from you today. And I thought it was Dr. Rosa gonna wrap up within 20 minutes, just because it's so intense, and then exceeds until almost 40 minutes. That's fine. All right then. So I have to a little bit summarize it, because you have been explaining, how fundamental issues study comparative law and why is it so important in our today's era, society 5.0. That's very important. That's why I'm writing down in here. And you have been explaining also how the significant comparative law works, the key concept and the principle behind it, how we have to study it. Also, you give also some examples, cases study, various domains in this comparative law issues. What are some benefits and challenges in studying comparative law? Well, thank you so much, and once again for your time and contribution. Let's give a big round of applause to Dr. Rosa. And I'd like to summon the great speakers. Thank you, and now time to from our second great speaker, Dr. Sascha. Please come over here. And he is a renowned expert on the same issue as comparative law and has published plenty of books and articles on the subjects. And he also associate professor comparative law in Maastricht University and consultant in a higher education institution. All right, and welcome to Dr. Sascha. Times and place yours.
Good afternoon, everybody, and thank you very much for the kind introduction, Pak Sri Wahyu. Thank you also very much for having me here. Thank you to the Dean of the Faculty of Law of Universitas Terbuka to bring me here today. It is a great honor, like Bu Rosa already said, to be here and to lecture to such a large public, probably the largest that I have ever been lecturing to. I think that many of the topics that I will talk about today will actually connect quite closely to what Bu Rosa introduced. For example, I will also come back to the problem of comparing, but also the benefits of comparing. So without further ado, I would like to start a speech that I have felt fit to entitle Constitution Making, Concepts, Context and Complications. So I'm going to go into some concepts of constitutionalism. What are constitutions? What are they for? Specifically, constitutions in democratic countries. I'm going to outline a little bit the contexts in which constitutions operate and the contexts in which and for which they are designed, and the complications which drafters, founding fathers, founding mothers are facing when constructing, building constitutions, and also states when reforming or further developing their constitutional systems. And from an outsider's perspective, I am a comparativist, so for me it is particularly interesting to look at foreign constitutions. And the Indonesian constitution is a fascinating one to us, because on the one hand, it is relatively foreign in many of its concepts to constitutions that Western European constitutional scholars usually study. On the other hand, it has done exactly what Bu Rosa presented as one of the dangers, namely conducted many legal transplants, taken legal concepts from outside Indonesia and supplanting them into the Indonesian constitution. So it is quite an interesting subject to compare with and to look what has happened in the process of constitution making and constitutional reform and how that compares to elsewhere in the country. So I will conclude with an outsider's perspective, very explicitly so, on Indonesian constitutional history, and particular picking one example from the Indonesian constitution, that is Article 33. Now let us start with a very general outlook on what constitutions are, what the role and meanings of the constitution in a state actually is. In a very general fashion, I think we can state that constitutions are always conduits between the social world and the legal world, in the sense that constitutions are, of course, legal documents, so they are laws in a way. They contain concrete legal norms that regulate human behavior, that give rules, that give procedures, and that have legal validity. Very often, when we have constitutional review, for example, also justiciable legal rules. On the other hand, constitutions are not only that. Constitutions are at the same time not just concrete legal norms themselves, they are also the capstone, the pinnacle of the legal system, and as such, the piece of the legal system which connects law to the social world, to the society in which the law operates. And as such, it is important to look at the functions that constitutions have, legally but also socially speaking. So legally, it is relatively clear what most constitutions do. They contain fundamental rules for the life of a state. They constitute the state, right? As such, they contain, for example, definitions. What is the territory of the country can be a matter of constitutional law. In many cases, who are the people, who is the nation that this state, that inhabits this state? And most importantly, constitutions define institutions. There shall be a president of the republic, there shall be a legislature, which we call the DPR, etc., etc. There shall be a constitutional court. So all the most important institutions of the state are usually defined in the constitution and then attributed with competences. So there shall be a president of the republic invested with the following competences, A, B, and C, and so on. And doing this for all the main institutions, including, by the way, also for the people who, of course, have an important function, like electing their leaders in a democratic society, the Constitution, step by step, builds the edifice that is the state, the machinery by which the state works. And lastly, the Constitution adds to this regulation. Regulation, for example, about processes. Exactly how does a law come into being? What is the legislative process? Exactly how can a constitutional court, and under which circumstances, overturn the decision of a democratically elected legislator? How does an election system work, etc.? So definition, attribution, and regulation are the three main legal functions of the Constitution, but on top of that, constitutions are also elements of identification. They contain a lot of symbolism. Have you ever seen the American Constitution, which is literally a physical document in a frame behind glass in a museum in the US, which thousands and thousands of school children go to visit each year because it is an item of national identification? So in many constitutions there are descriptions of the flag, there are notions of the national anthem, or other items of identification, and often the Constitution itself is such an item of national identification. I myself am from Germany. In Germany, after the atrocities of the Nazi period and the Second World War, national pride or a national sense of patriotism was for a very long time frowned upon, but instead what we call constitutional patriotism has emerged. Pride in this particularly well-working, for a long time at least, constitutional system that we have built after this negative experience is very much an item of national identification in my country. That said, constitutions as such are a thin concept. There is no fixed definition of what a constitution needs to look like. There is no minimum requirement, as it were. Constitutions can, for example, be largely unwritten. Think of the Constitution of the United Kingdom. There is no one document behind glass in a museum like in the US for the United Kingdom. Still, it would be wrong to say that the United Kingdom doesn't have a constitution. It would even be wrong to say that it is completely unwritten, because many parts of it are written. There's a Magna Carta, 1215, 1,000 years old almost, or 800 years. There is the Bill of Rights, 1689. There are other pieces of legislation, important pieces of legislation. The last one, perhaps the legislation sealing the exit of the UK from the European Union, that together define the UK constitution, but not in a single piece of paper. And many pieces of it even only in conventional rules. So it can be unwritten or it can be uncodified, as we say. It also can contain items that don't normally belong in the Constitution, such as specifications about trade. It can contain, it can also outsource items of constitutional relevance to legislation outside the Constitution itself, such as electoral rules. Many countries have an electoral code which is legislated in normal acts of parliament rather than the Constitution itself. Still, this piece of law is of constitutional importance and of constitutional rank often. So, no strict formal requirements. Now, in order to understand, to fully comprehend and also make a good comparison, Rosa talked earlier about the impossibility sometimes of comparing apples with apples because these apples operate or grow in different circumstances. So to fully comprehend the meaning of a constitution, it is important to pay some attention to the contexts in which constitutions are created and the purposes they are created for. On the one hand, constitutions always are products of their time. So constitutions are always designed in front of a certain historical or political backdrop. It never happens that on a normal Monday morning, in a well-functioning state, in peaceful times, people sit down and decide to draft a new constitution. Constitutions usually, constitutional drafting endeavors usually occur in times of upheaval. For example, when states become independent from colonial powers. In times of war or revolution. For example, the Indonesian constitution was drafted before Indonesia actually became independent. It was an aspirational project, right? In moments of deep political crisis. Most recently, Chile, for example, a country which knows very severe social inequality, which has led to deep political crisis, has decided to hold a constitutional convention and a referendum on a new constitution, which so far has failed, so the process is ongoing. But it usually moments of difficulty, moments of war, of crisis, of decolonization, of revolution in which constitutions are made. Second class of contexts in which constitutions or against which constitutions have to be read is the social and geographic circumstances in which they have to operate. It makes a difference whether we draft a constitution for a largely homogeneous society in which there is little ethnic division, little religious diversity, little linguistic diversity, or whether we draft a constitution for a country like Indonesia, which is extremely diverse. It consists of thousands of islands, people initially not speaking the same language, or very few of them, different religions, etc. Or whether we make a constitution for a country in which resources are divided homogeneously or not at all. A huge challenge, for example, for the making of the new constitution for Iraq after the war, 2005. So territory, topography, resource, population density, all of these factors have an impact on what is realizable as a political system in a newly drafted constitution and what is not. So these factors do play a role. And lastly, of course, there is the presence, the pre-constitutional presence, as it were, of political traditions, of what has always been done, of existing norms and values, and therefore constitutions can only ever be aspirational projects. So Rosa referring to the Indonesian situation already mentioned, we have to take into account the local culture and the local traditions and the local values. Now, this may be true, but very often constitutions are also projects of social engineering. So very often they do not reflect what is already the case. They often reflect what the drafters want to be the case in some utopian or nearer or further future. So constitutions are aspirational, they are visionary documents, and they are not blueprints or photographs of the situation that the drafters find. And this is an important thing to keep in mind when we compare constitutions. Very often, when we read the constitution and then look at the political realities in the country, we see some difference there. We see some disparity between what the Constitution says and what actually happens on the ground. But this is not something to surprise us because of what constitutions are. They are legal rules, yes, but they are also these aspirational, future-looking documents. Have some examples here. The US Constitution, if you read it, and you know something about the historical backdrop against which it has been made, you are much better able to understand why the Constitution looks as it does and why the US system today works as it does. This is what makes comparative law attractive. It allows us to understand better what happens in the world. The US Constitution was made at a time when most countries in the old Europe were still monarchies, some of them absolutist monarchies. At the same time, it was made in a time where Enlightenment, so the tradition of rationality and the coming of new scientific methods started to take hold in society. And you see in the US Constitution a strong desire to bring some liberty to the individual, liberty from the arbitrariness of the old monarchical regimes, and at the same time to bring some logic, to bring some science and some systematicity into governance. And this is very much the background against which you can understand the US Constitution. Look at the German Constitution. You can read that whole thing of over 140 articles as one big exercise in this may never happen again, right? In the Nazi period and the war, Germany caused one of the biggest catastrophes in human history. The state that was later built after this has one main task which is more important than all others, and that is to never let that happen again. So we have very strong federalism, decentralization. Education may not be centrally governed. Why? Because we need to prevent any political party from ever taking hold of the content of school curricula. These kinds of things are a direct expression of the historical context in which the Constitution was made. We have a strong constitutional court which can overturn legislation if it is unconstitutional. We have very strong fundamental rights. Article 1 of the Constitution, human dignity is inviolable, is one of the most important and prominent provisions of the German Constitution. Against this political backdrop, it makes sense. Think of France, where in a situation of war, the war against Algerian independence in the 60s, a new state had to be created in which at the behest of the president, whom the population wanted to have back for another term in office, Charles de Gaulle, demanded a strong executive and a rationalized, streamlined, relatively weak legislature which could not interfere too much with effective executive action. So we now have a French constitution with a very strong double-headed executive, strong president, a strong prime minister, and a relatively weak parliament. Unthinkable in other democratic states, logical against this historic backdrop. And we have Indonesia, where the making of the constitution stood at the beginning, actually, of a several years long independence struggle against the Dutch colonizers, where state building was in the foreground, because before Dutch colonialism, Indonesia had never been one state. So the idea of it becoming one state after decolonization was by no means a given. This was a vision. It was an aspiration, something for the future. So the idea of creating state aims, having a national principle, having a one country, one people, one language principle enshrined in the Constitution, all of this can be read against this historical backdrop. Because this is so, because constitutions are always contextual, there's a couple of dilemmas that the makers of constitution and also the makers of constitutional change and development and amendments must always face. On the one hand, you want a constitution to be a stable system, a system of meaningful, stable rules that cannot easily be undermined and that is clear enough to govern. So the rules need to be stable. It shouldn't be too easy to overturn or to change or to do away with the Constitution. And at the same time, a Constitution must also be flexible because it is supposed to hold for a long time into the future. And we do not know what technological challenges, natural challenges, or political challenges we face 50 years from now. So constitutions should be designed in a way that has a degree of openness and variability. But this is hard to combine. Huh? Clarity, strictness, efficiency, and on the other hand, openness and flexibility. This leads to difficult choices. Think, for example, of the question of amendability. How easy, and according to what process, should we be able to change the Constitution if we think it's necessary to do so? In the US, the Founding Fathers chose for a system which made it very hard. In today's political reality, it's virtually impossible to change the Constitution. This is why it has only been changed 27 times in the last 200 years. In constitutional interpretation in the US, there's always the debate about how should we read it, how should we interpret it. Should we interpret it in the way that the original drafters meant it? But if so, is that even possible? If we read the Second Amendment, which permits every citizen the right to bear arms, so the right to carry a weapon, can we actually read this in the way that people meant this 200 years ago? They cannot have imagined a machine gun when they made this regulation, right? So what do we mean if we say originalism? Or do we go with something like a living instrument doctrine, which is the idea that the European Court of Human Rights gives to the European Convention on Human Rights, which says that while the text remains the same, the meaning of the words evolve over time. So that, for example, the concept of a right to private life today means something altogether different from what it meant in the 1950s when the convention was drafted. The people who drafted it could never have imagined that today it can mean something like the right to live in a silent environment, to have good sleep at night. But in fact, this is what the Court of Human Rights has in the meantime read into it in a case about people who live close to an airport. Another example, another dilemma is about constitutional review. On the one hand, we can ask ourselves if a constitution really constitutes anything, if it really has the power to structure the state permanently in a certain way, if there's no authority that can rein in, that can pose actual constraints to those in power, to the legislators and also to the executives. On the other hand, we can ask ourselves, with what legitimacy should judges, who often have a lower democratic level of legitimacy and accountability, who are mostly not elected, at least not directly, have a greater say over the content of our laws, than the democratically elected parliamentarians who make the laws. This is one of the ongoing debates, and states find very different answers to this, and these very different answers are deeply rooted in the historical context and in the political cultures in which constitutions are made. The Dutch Constitution, Article 120, explicitly prohibits constitutional review. It's very short. The judge shall not enter into the constitutional review of legislation. No constitutional review. The German Constitution creates a very strong constitutional court which can do abstract review, concrete review, review on individual petitions, review on petitions by political party. It has very strong powers. All against the backdrop of how the constitutions have been made. And you see also in the design of the Constitutional Court of Indonesia, which is a relatively young institution, that inspiration has explicitly been sought in countries where constitutional adjudicators have been in operation and in the procedures that they use. A last dilemma is about the clarity of norms. We want constitutions to be clear, because if they are not clear, we can't apply them, and if we can't apply them, we cannot hold anything against their standard. At the same time, we want constitutions to be open enough to remain valid and relevant for a long time. Again, going back to the American Constitution, take again the article, the Second Amendment on the right to bear arms, for a well-regulated militia being essential to the functioning of the state, and so on. These are vague words. Today it is hard to read concrete, relevant meaning into it without engaging in too much, either in too much creativity or in too much originalism, which is problematic. Or take again Article 1 of the German Constitution. Human dignity is inviolable. State action must protect and foster it. But what is human dignity? And when exactly is human dignity violated? What needs to happen? What does politics have to do to protect human dignity? It's a vague concept, but is it too vague? These are often choices that are difficult to make. One of my favorite examples, I'm going to come back to it at the end of the presentation, Article 33 of the Indonesian Constitution, which gives the state the task to manage natural resources of the country according to the family principle. What is that? We may all intuitively have a good idea of what a good family looks like and how it works, but it's very likely that people in different parts of the world, or even different parts of this country, have a very different idea of what exactly that entails. Is this principle clear enough to be justiciable, clear enough to hold any legislation against? So these are complications. Let's look at the concept of constitutionalism for a moment, because I said I'm only talking about democratic constitutions, and in a modern understanding that there is some consensus about today, constitutionalism entails a couple of base notions. First, the idea that constitutions legally constrain state authority. They present legal norms which limit the authority of the state, and not just nominally, but significantly. So the extended notion, legal norms impose significant limitations on state authority, and in order to do so, they are entrenched. That is, they can also not easily, by a simple political decision, be taken away. Not enough yet. Even entrenched limitation of state authority require, they do require a hierarchy of legal norms and a separation of powers, but not necessarily democracy. So we add democracy to the equation and say constitutional democracy means that not only is there the rule of law, not only are there significant constraints on government, but there is also the principle that law ultimately must emanate from the will of the people, the democracy principle. And lastly, because the will of the people could be, for example, to discriminate against minorities, to enslave a neighboring people, etc., we add to the equation the notion of fundamental rights. Even though there is the rule of law, and even though what the law is determined by democratic majorities, they must never go as far as to violate the rights of minorities as well. This is why fundamental rights need to be protected. Resulting in this pyramid, a three-sided pyramid in which the rule of law, fundamental rights, and the democracy principle are equally important to the notion of democratic constitutionalism as a whole. And if either of the sides, either of the three sides of the pyramid gets eaten away or too weak, the whole pyramid can collapse. If there is too little democracy, then despite rule of law and fundamental rights, arbitrariness can reign. There can be rule against the people. If there is no rule of law, then despite democracy and fundamental rights, legal rules might not be observed and the Constitution is not lived by. If there is no fundamental rights protection, we can get dictatorship of the majorities. None of this we want, so all three sides are equally important to democratic constitutionalisms. But if we compare how states solve this problem, we see differences. We see that the same answers sometimes get different questions depending on different contexts and on different visions. And this is how we learn by engaging in comparative constitutional law about options, also about our own options. We learn to understand our own past choices better, and we learn to understand our own future choices better and their possible consequences. And at the same time, we learn that making legal transplants from one constitutional system to another is very, very difficult. One thing we do learn is that constitutionalism, so this system, mandates positive law to a certain degree. So having positive law is necessary to constrain state authority because the content of the law must be reasonably clear. The norms need not necessarily be identical throughout the territory. You can make amends for local tradition, etc. But there shouldn't be any norms, even locally, which contradict the fundamentals of the central system. Rules that contradict constitutional norms are valid, and valid positive norms can't give rise to exceptions because then the constitutional system breaks. This is interesting in the Indonesian concept because Indonesia has this dichotomy. I have little time. How much time do I have?
Well, I think you still have 5 minutes more.
5 minutes more. Okay, I will be quick about this. Let's have one little illustration of this and then I'm already done. Indonesia is a country where the historical background tells us that it has not always subscribed to the idea of democratic constitutionalism, but it does today, so there has been a process of constitutional reform, of constitutional amendment also. And yet, the Constitution today retains features which seem contradictory to the idea of democratic constitutionalism. And to understand this well, both for those who try to democratize the country further, to protect democracy and to work on the Constitution, and to those who just try to understand it from an outsider's perspective, it is necessary to understand the backgrounds. I have a whole story about how this background came into being and how some of the ideas which mark Indonesian exceptionalism, the constitutional reference to adat law, for example, or also the peculiar nature of Article 33, is narrowly intertwined with the colonial history, with the independence struggle, and with the unique system that was built in the background of both. But I don't have the time to go into very much detail. You can see pretty much of it on the slides, which I hope are made available to you. Let's jump to the conclusion. The conclusion being that constitution making and constitution's development is never independent of context. Therefore alone, studying comparative constitutional law must always include an element of studying socio-legal studies as well, of studying history, of studying politics. Doing so is very useful. It is very useful also for lawyers, for those who build the state, for those who think how should we go on in the future and what needs to change in order to make things better in a given country, and to do so carefully and without too much of a rush. So this is an emphatic pleading for the practice of comparative constitutional law and comparative law in general. At the same time, a warning that legal transplants always come with their own problems. The success or failure of a constitutional system always depends on many aspects, but the spectrum of possibilities is not limitless, so it's not arbitrary. Constitutions do have effects. Constitutions are important, and to think about it well when we operate one, when we draft one, when we amend one, is very, very essential to the life of a given state. Thank you very much for your kind attention. And I fear that we don't have much time for a Q&A.
I don't think so, as I guess, we're just having such limited times. Thank you very much, Dr. Sascha, for such great lecturing. And we have come to really end of our general lectures, comparative law, and I hope have you enjoyed all of the sessions and gained some valuable insight and knowledge from our speakers. Before we close this session, let me briefly summarize the main point and takeaways from our speakers. First, from Dr. Rosa, she explained to us how significant to study comparative law and showed to us that comparative law works and what are the key concepts and principles that behind it, and it gives benefit to us. That's from Dr. Rosa. And from Dr. Sascha, he shared with us how comparative law takes place in other countries and how this constitution is in the making, and then bring also such complication, and give us some controversial issues also in this constitution, and tips and advice how to start and take a look at comparative law in a different analytical perspective. We also had some lively, interesting discussion. No, we don't have it. And then I would like to finally thank you to all of you for joining us today. And I hope we have learned something new and useful from this seminar. This general lectures. And please feel probably any other request to the students to fill in the forms. Please do fill for the evaluation of these sessions, and because your feedback is going to be important for us. And thank you very much and have a great day. Assalamualaikum warahmatullahi wabarakatuh.
That's the material delivery on general lecture led by Mr. Dr. Sri Wahyu Kridasakti SH M.Si. And for all the speakers, Mrs. Dr. Rosaristawati SH LL.M, Mr. Sascha LL.B LL.M Ph.D. Thank you for the engaging session. We all very enjoy. All right, ladies and gentlemen, we are reaching the end of the agenda. Let us close this session with reading Hamdalah together. Alhamdulillah. Thus, the series event for the general lecture series on comparative law, me, Helen Ardana, as the Master of Ceremony, would like to thank the audience for the participations, and we also apologize if there are words or actions that are less pleasing. That is all from us. Wassalamualaikum warahmatullahi wabarakatuh.